Go.
Perfect. Awesome.
All right. Well, welcome everybody to today's webinar. This topic for today is an interesting one, albeit maybe a dry one for some people. Legal and liability issues in a post-COVID fitness industry. Certainly, COVID-19 has changed the dynamics of our industry tremendously. Now we're seeing much more virtual workouts. There are all different platforms out there that trainers can leverage to do these virtual workouts on. There's a whole host of legal concerns that go along with that. And today we brought in Michael Melfi, who is an attorney who I've worked with at Applied Fitness Solutions for several years. Great guy, good friend. Also happens to be an alum of the School of Kinesiology at the University of Michigan, although he did not go into the kinesiology path. He is a triathlete and stays, very, very active between him and his wife and his kids. And I'm excited to have Michael on here. And Michael, to start it off, just give everyone a little bit of a idea of your background to provide some context for our conversation.
Absolutely. Thank you so much for having me. I really appreciate being here. And as you said, I went to Michigan undergraduate thinking I was actually going to go into the shoe industry. One thing led me another. I ended up with a JD MBA and then a legal career, really working with a lot of, I would say, entrepreneurial clients, very, I'd say, athletically minded clients, people who are driven to produce results. And really that's where my career is taking me, as I get to work with really amazing entrepreneurial clients who are seeking to really grow their business, who, probably sometimes don't have all the answers, right? And so they need an outside person they can turn to. And I get to be that outside general counsel, which means they come when they have a myriad of legal issues that range from, hey, I have a partner, what do I do in this situation? Hey, I need to raise some money. Hey, I have a PPP loan. Hey, I have an employment issue. Hey, I have an IP issue. The questions kind of are very broad in nature. It allows me to be able to be that kind of trusted partner, that trusted advisor. And if I don't have the answer, I'm a part of a team with 200 attorneys across the country, licensed in 22 states. And I call up one of them and say, here's my situation. Can we help them solve it? And so that's been a great opportunity for me to be able to create a ton of value for the people I work with. I have a natural personal interest in the health and fitness industry, as you know. I will say having 2 kids under the age of 2 definitely put a damper on our marathon and triathlon training, but we are getting back into it now and have all the necessary equipment to make it happen. But it's something that's near and dear to our hearts. And so getting to speak today I'm really enthusiastic about that. And I really appreciate the opportunity to come on and hopefully make it as fun as we can. You're right, it is pretty dry. And I realize, people don't love calling their lawyers. But the one thing I would say before we dive in is that we tried to pick topics that are going to be things you should consider dealing with. Most people don't want to deal with a legal issue until it's become a problem. And Michael, you and I have talked about, I have no problem getting those phone calls, but that usually means it's going to be more expensive to resolve. Mm-hmm. And a lot of times dealing with something on the front end is hundreds of dollars. Dealing with on the back end is thousands or tens of thousands of dollars. And so the more that you can take the steps to just deal with these upfront, that's the whole point, is we just want to make sure that hey, here's where the potholes are down the road. You would never want one of your clients just diving in and doing the heaviest weights. You want them to warm up. You maybe want them to stretch. You want to make sure they get things in place so they don't hurt themselves. I consider this conversation the same type of thing.
Yeah, and I think what's really important to note there, and we're very used to talking about this in fitness, is the idea of preventative health. It costs hundreds of dollars, maybe thousands of dollars to prevent diabetes from happening. It costs hundreds of thousands of dollars to treat diabetes once it happens. And so I think this is the same conversation. And I'm excited to get into this. And I will say, from our relationship that we've had, having that trusted resource to be able to bounce things off of can be very, very helpful, because myself and the people that are watching this aren't legal experts. Well, Donald Jordan, one of our board members, is watching this, who is a legal expert. He is a lawyer, and he also runs F45 out in the Livonia area. So he has a little bit of expertise. But Michael, the first thing I want to start with, just to level set for everyone, and let's assume that the people watching this are a combination of independent entrepreneurs that have their own physical business, maybe people who are doing things online, or maybe trainers who work for other clubs. One thing, I didn't send you this in the questions ahead of time, but I was thinking about it. We should talk about 2 things that are really critical right off the bat. If you're doing this on your own, why should you incorporate, and why should you get insurance? Like, those just seem like, added expenses and added fuss, but fundamentally those prevent some pretty big potholes down the line. So touch on that real quick, just to level set.
Yeah, absolutely. That's a great question, and I'm glad you brought that up. And I get asked all the time, do I need an entity formed? And the answer is no. You can technically take money in, you can run it through your you can run it through your personal 1040, and you can pay taxes to Uncle Sam. Now you're asking me as a lawyer, would I get one? Yes. And why is that important? The reason it's important is that when you are setting up an entity, what you want to make sure you're doing is it creates a shell around you. It creates a barrier around you, so that if someone were to have an issue to come after you, they're not coming after you personally. When done properly, the setting up the entity, whether it be an LLC or a corporation, that's a whole separate conversation. But let's just say it's an LLC, you're going to set that up. And if someone had an issue, while they may be able to try to say to you, well, hey, I'm going to name you individually. Well, actually, the services were provided through this entity. I work for this entity. And so you'd have to go after this entity because I'm just an employee of that entity. And so it protects you, so they can't pierce the corporate veil and come after you for that. And so having an entity is an important part. It's very nominal. I'm the first to say, hey, you can do this yourself. You can go online, go to the state of Michigan, you can file it yourself. For a nominal amount of money, I can definitely help you get that set up. If you have partners, I would highly, highly, highly recommend you get an entity set up, and also take the time to set up the proper corporate governance. That's typically a shareholder agreement or an operating agreement. Non-liability reasons is what inevitably business relationships always don't end well. And having that document in place can be so, so important. So that's the whole setting up an entity side, and that's really important to have. The second side of it, I would say, is the insurance question. And absolutely, for what an insurance policy costs compared to what the damages could be on the backside, I would always recommend having insurance. I just said this yesterday to someone. I said, and I said to them, they were hiring vendors. And I said, if a vendor's not willing to get a basic umbrella policy, is that the type of vendor you want to be using? They're cutting corners. In your industry, I'm more concerned that you're teaching people, helping people, educating people, professionally servicing people. And it has to do with health, it has to do with fitness, it has to do with wellness. We hope it always goes perfectly in all our model clients. But inevitably, if something goes wrong, having an LLC and the insurance set up is worth it. And here's the thing, whatever you charge for your hourly rate, figure out what your insurance is, blend it over your total hours for the year, and pass it on to the client. So many people think like, oh, I gotta pay that now and it's coming out of my pocket. I would just say, move your price up to $2 or $3 or $5 you have to a year to cover that cost, but definitely have that in place.
Yeah.
Great question.
Yeah, and thank you, Michael. And the great news is that for those of you who are watching this that are certified professionals, every professional organization has an insurance company that they partner with that gives discounted rates. And these are no more than $200, $300, $400, $500 per year in some cases for individual professionals. Certainly, if you run a facility, it's going to increase. But I know from running AFS for 14 years now, just 2 or 3 claims we've had over that period of time has covered our insurance policies tenfold. So and we can get into all the nuance of everything that you just talked about. And again, I do want to reiterate that what he said about partners and really considering how that is set up is important. But I want to get beyond the nuance of that, because that might even make the conversation a little bit drier. And I want to get into now post-COVID here. And technology is obviously rapidly transforming our industry, just like every industry. And privacy becomes a real concern, particularly data privacy. What should trainers and exercise professionals that are working in the virtual domain know as it relates to privacy policy? And also, I'll throw in there, people from different states might be watching this. So how do we have to take state-by-state considerations in place?
So it's really, I'm going to speak mainly to Michigan, but you're exactly right. Privacy laws around the country differ, and depending what state you're in. And so it does affect that. And you will want to look at a local level, regional level on what's going on. In particular, Michigan has some laws that protect around like payment of cards and social security numbers and driver's license that you may have obtained as part of a client credit check, or when you were onboarding them as a new client, you have this application that you pulled offline, or you got it from some standard manual. You're going to want to make sure you're taking people's personal information. And the minute you do start taking their information, privacy laws, there's data privacy that takes into effect. Real quick, what is that? So basically, you'll hear things like CCPA or GDPR. basically what's happening is there's a movement in the legal profession that we're starting to protect, or the governments are starting to protect people's personal information, their personal health information, PII or PHI. And so what's happening now is that when you're getting that information, we used to just take an application and it was like no big deal. Now, when you're getting that, you now have certain obligations. And so there's a heightened level or heightened duty of your obligations to the customer whose information you took. And so, they're going to have greater protections usually than they used to have. So the old days of writing it on a carbon application and just running through doesn't work anymore. And so, when you start having information, you keep food logs or diet logs. You're going to keep workout logs. You may have medical details. Did you take a blood pressure, or anything that could be considered medical information now starts to be part of the data privacy you're going to want to consider. And again, I don't want to get too far down the rabbit hole, but for those people listening, if there's a takeaway, is if you're gathering data, any kind of data, information about the person, information about their workouts, information about their health and wellness, you're gathering some form of data. You're going to want to make sure that you have some type of data processing policy, something that talks about how you're going to do that. And any documents you have with the client, the customer, needs to have information there, whether it be a waiver, things like that. I noticed when I came on here, there's a little pop-up. Someone, obviously did a good job of making sure that I consented to being in this room. It seems like such a small thing, but that's an important part, especially if it's later going to be used down the road in another setting or for you to commercialize. And so it's very important that when you're taking in that personal information, you treat it as just that personal information that is an asset to the person, not to you. And so you're borrowing someone else's information. So how you protect that is very important. I think another thing to point out along that line is that, if there are privacy waivers that you do have in place, it should acknowledge, hey, this class may be redistributed, or this class may be later used for commercial use. Now that we're on the web, we're repurposing our content. It could be something where someone thinks it's not a big deal, where they took a picture of themselves and their virtual class. How many times have you seen a Zoom call where you see this whole class? Technically, you're not supposed to do that without written permission. And so, you may say, oh, that's a lawyer just being overly lawyerly, but I can tell you the fines that come along with these new regulations are going to continue to be implemented and increased. And so there will be, we saw it in Europe with the GDPR. The US is moving to making sure that the data of the customer is owned by the customer. And the last thing I would say is that, a lot of this has to do with IT. If you have an IT provider, call them up. Hey, we're doing this. What do we do about this? How do we handle this? Your IT provider should be pretty knowledgeable in this area, and should be something that can provide you around the security and how are we managing and maintaining this. It's an important part. And I think that the last part, this sometimes goes unnoticed, is, hey, I have a website, right? And on that website, I had some developer put it up for me, but is the terms and use and the privacy policy actually applicable to what you do? I had a client recently contact me, and they do a lot of health and wellness kind of coaching and training online. It's all done online. Nothing's in person. And they gave me a policy, and it was a gym, like a physical gym policy they were using on their website. So although they had a virtual business, when you read their policy, it all had to do with a physical gym, and it talked about coming into the gym and membership. That was part of the language, and it just didn't even fit their business. And so it's important that, if you do have terms of use and privacy policy, it's important. You may say, hey, well, I'm posting all my content to Instagram or some other social media channel, and they have terms and conditions there. That's fine, but you may want to consider, how are you using that content, and where are you using it? And are you taking people's testimonials from social media and repurposing them? Those are all things to consider when it comes to privacy. It's something that honestly has just become it's been around for a while, but it's become to the forefront in the last probably 48 months. And that was even pre-COVID. COVID just escalated the issue.
Yeah, I'm so glad you mentioned the client that came to you regarding their privacy policy being wholly different now than it was before COVID. And I bet a number of us that are watching this, even as you said that, I'm thinking, wow, I wonder how all of our documentation, how up to date it is. I think many of us still probably have some outdated documents and outdated language. So it would probably behoove everyone that's listening to just go back and scrub through that to see if it reflects what your business is currently doing. Either, like in the case of your client, it completely shifted, or in the case of many businesses now, we're just doing the hybridized approach. We're doing some stuff that's in person and some stuff that's virtual.
and I think, I'm digressing from the issue of privacy, but I'll give you an example. I had another client who used a well-known website hosting, providing website building company, and they just assumed that their website was compliant. They got slapped with an ADA lawsuit. It was not, although they fixed it, it was not inexpensive for us to settle that. And perfect example, had they called on the front end, it would have been hundreds of dollars or maybe $1,000 problem, right? Maybe $2,000 at the most. I can tell you it was exorbitantly more than that to settle this because they just assumed, oh, well, I pay someone for the website, it's all handled. It would have been a simple legal question. They could have said, is my website ADA compliant? It would have been handled. Same thing with the privacy. You probably either copied them from somewhere else. It happens all the time. Or your web developer put them there and who knows where they got them from.
Yep.
Take the hour or two to read it. It's going to be boring and dry, but read it. Does this even apply to my business? And if it doesn't, get it corrected.
Yeah, great. And again, for everyone who's watching, there are off-the-shelf solutions in our industry out there that do a pretty good job of this. And I can't speak to them from a legal perspective, but just they are big enough players that one would assume they have many of these things covered. Although, as Michael said, do your due diligence and dig in there a little bit. But ABC Fitness Solutions and their Trainerize platform, IntelliVideo, which is specific for virtual content for fitness professionals, Mind Body and Zen Planner as big platforms that are out there. Don't reinvent the wheel with this stuff if you don't have to. Don't do it in a bunch of just random Excel workbooks or pieces of paper. Not only will it save you time, but it probably makes you a little bit more legally protected by going through these big companies. But as Michael said, do your homework on that.
Yeah.
So I want to get into general liability next. And it's interesting what we talked about with regard to privacy in that one client you mentioned, because we also have for years used waivers in our industry that basically talk about physical events in the gym. Now we're doing these virtual workouts. How do we have to consider general liability in the virtual domain? And how do we ensure that our workouts and our teams are properly protected?
Yeah, and I think it's important. And I have a really good example I can share of a public case we're working on right now. But I will. This is a serious concern. And may say, oh, it's not a big deal. But think about if people are coming in person. There's a chance that someone's going to be hurt or injured coming to your physical class. And if that were to happen, they would most likely go to a doctor or go seek medical attention. And if it was severe enough, they may consider calling up a lawyer. And you see their names all over our TV, our billboards, and you'll end up getting potentially named in a lawsuit on that. And that's where this goes down, is this general liability of you are giving a service, you were providing, because it's technically a service, you're a professional, you're providing a service, you're providing education. The person is then taking that and using it, having the right disclaimers, having the right waivers in place is important still, even online. Some people think, well, I'm just doing this virtually, it's not a big a deal. I'd still have the waiver in place. The same waivers you would have, they may need to be slightly modified to address virtual environments or online education or training, but the same type of waivers are because the person on the other end is still doing the same workout. And so they could have the same injuries. And so it's important that someone signing up for a remote class or a virtual class, they have an agreement, a waiver that includes standard liability protections and releases, and the kind of legal language that says anyone who's attending will have be medically fit to take the class, and are adults and good health standing, all that good language, the kind of buzzwords that need to be in there. Some things you don't think about is the setting is safe and appropriate for the class, right? So you never thought about before because everyone was coming to your space and you had it prepared for the class. Now someone's doing it in their den / office / kitchen / kids playroom / bedroom, and who knows what's hanging above them, or there's a hanging TV, or I'm pointing up and I have a light above me. There was no chandelier ever before at the gym that now we have to think about, because when you designed your physical environments, you designed them for that. Now you have someone who's not, or who's throwing around a kettlebell. Well, you never had to worry about a kettlebell being an issue before in your gyms. Now you do. So those are things you really want to think about. It's an important situation that before was never an issue, because they came in, your gym was properly prepared for someone to work out. Something just to consider is from a general liability standpoint. So those waivers that you previously used, and maybe Michael, there may be some people on here who said, what waiver? We never did that, right?
Right.
So make sure you have it. But if you did have one, it needs to make sure it takes into account the new environment, because it's a new situation. And I think to that point, what's interesting is most people just say, oh, I went on Zoom and I did a call. And what you don't think about is, now as a lawyer, I think about all the relationships. You had a relationship with Zoom, right? You had a relationship with the person on the other side of it. Well, everyone who's on the other side of that call. You potentially had a relationship if you're the gym owner and it wasn't you and it was a trainer or an employee. There's a relationship there. All those relationships should have some type of language that is mitigating the risk of that relationship. So with the employee, it's an employee-employer relationship, contractor-con relationship. With the client or the customer, I don't use the word patient, but there's a relationship there as well. You have some relationship with Zoom and what you can do for that. And they're always changing it. Well, they're a good platform. I'm using Zoom. It could be Ring Central, could be any of the ones you use. Maybe you're doing it on FaceTime. You got to be thinking about what is your relationship and what does that platform allow you to do or not do. So it's important to think about that as well when you're looking at the platform and the terms and conditions for your platform. So I think those are all important parts to consider. And if you're still at a space doing it, there's a relationship to you in the space where you're doing your training, even if it is virtual. And so those are all relationships to consider. And I think the question is there anything here that could create liability? Is there any risk here? And if it is, has that been properly documented? That to me is how you handle the general liability when we're dealing in this virtual environment.
Great. Yeah, a lot of important things there. I have a follow-up question that's interesting, and it strikes me that this is happening a lot. Let's say that I just post on Facebook Live. Let's say I have a group on Facebook and I posted a workout video on Facebook Live or Instagram Live, and people could just access it openly through a social media platform. Is there anything that we can be doing to mitigate liability there, where it would be impossible for people to physically sign any sort of a waiver?
Yeah. And so, this is my disclaimer that this should not be construed as legal advice, and you should hire a lawyer to get this advised, right? But on a fact-based question that, hey, I'm going to produce content on a social media platform, do I have to worry about that? And the short answer is yes. At the end of the day, if someone were to get injured and they ask, how did you get injured? And I said, oh, I was on social media. Well, you're probably not going to sue Facebook and Mark Zuckerberg. But there is a good chance that the person who put out the content, if I were a lawyer, I would be naming that person but for them taking, now whether or not I would win or not, but that's where the liability comes in. And whether that goes anywhere, there's merits for that claim. That's a whole nother conversation. And depending on my state, it's different. But why even suscept yourself to that liability when all it would have taken was, when you go live, put something in the chat that says, by attending this Facebook Live training, you are agree and consent to X, Y, and Z. It literally will just be a post, or it could be if you have an event and you're posting the event and someone's going to be signing up, when they get the confirmation email, have it right in there. It takes all of 15 minutes to put that in there, and it could be all the difference. Whether or not it's enforceable or not, let the courts argue that out.
Sure.
But you can say to someone, well, when you agreed, you consented to this, and you told me you were in great physical shape. You didn't tell me you were a diabetic with heart conditions. Because if you had, I would have told you not to participate.
Perfect. Yeah. So
things like that.
Yeah.
No. And one kind of quick question, it's in the sports industry. It's not directly related to what you do, but I think it's just a good example. And I can talk about this because it's public. I represent a professional sports team, and we recently got a workers' compensation claim from one of their players who played on their team. Now, again, this is a player. This is not this is not per se a customer, but just to show you where different case law is in different states. This is not in Michigan, but it is just so you guys can see, we are being currently a workers' comp claim that we have to answer in California because we went out there and played there, and so they have jurisdiction over us. And this is a person who played a professional sport, who susceptible themselves to injury, who's now able to bring a workers' comp claim against them. So imagine that a trainer could potentially bring that claim. They are a worker who, over a period of time, said they were injured. Now, mind you, I want to give you a little more context on this. The player played from 2012 to 2015, and for only 1 month, they played for my client. The rest of the time they played after that in Europe. So even after they alleged the injury, they went back and continued playing. And this person's most likely going to get a judgment and going to be able to get some money from this. I share that with you because so often when we're dealing with physical activity, when we're dealing with sports, when we're dealing with health and wellness, we just kind of just, oh, that's fine. You're going to get injured. That's part of what you do. There are lawyers that are sitting on their side who make a living bringing lawsuits for this. So I'm not trying to be the sky is falling, but I don't do it. That's not what I do. That's not how I make a living. But there are people out there, and just take the time to protect yourself from some of these issues.
Yeah, that's that. I find that absolutely fascinating. I have not heard of the public case, but and I want to just reiterate one thing to our listeners, and then I'll add a follow-up question. The thing to reiterate is what Michael said there. Is it simply to those virtual workouts on Instagram Live or Facebook Live, just putting that disclaimer in there. Again, work with your lawyer to get the proper language to put that in there, but it's just something as simple as putting it in the chat. And I can almost guarantee that at least 50% of the people that are watching this who do virtual workouts probably don't stop to think about doing that. I know, because I'm just thinking about my staff and the stuff that we do on Facebook Live and Instagram Live, and I don't think they're doing it for 50% of the time. So I think that's such a good point. I do want to just really quick touch on the workers' comp thing, because you mentioned it, and obviously we're doing physical work now that is even different than what we did before. So maybe talk about some of the workers' comp considerations, just like you did from the client side of things.
Yeah. And so, you think about it. So the workers' comp is between the employer and the employee. That's the relationship, right? So now we're not talking about the person who's on the other side, who's listening to our instruction, training, education, someone who works for us. And in a workers' comp setting, the employer is responsible for the employee if they are injured on the job. And so that's where, the key is on the job. You can't go home and, you're mowing your lawn and you hurt yourself. That's not if you're mowing the lawn for your employer, different situation. But that's an important thing to consider that most people don't take into account. I can tell you stories after stories of someone went to run an errand to buy supplies and got in a car accident. And that was a workers' comp claim. It goes on. And it's something to seriously consider, that if you do have employees, making sure you have the right insurance in place. In that case, workers' comp insurance, making sure you have that in place. So that if something is to go wrong, as you said, the cost of it on the front end is a lot less expensive than what it's going to be on the back end to deal with. And so when you do have those relationships, it is something to take serious. There's a hotline you call. So if there is a workers' comp claim, someone just got rushed to the hospital, something happened, God forbid, there's a workers' comp claim, you can go, you call your insurance provider. They ask you for a series of 8 to 10 things, and you go through and you give it to them, and they'll help you with that. But I can tell you this: I'd rather be able to call my insurance provider to have them help me and deal with it in an issue than trying to get a lawyer, because it's going to be a lot more expensive for that lawyer than it would be for that insurance policy.
Yeah, and just again, for everyone who's listening, calling your insurance provider, your general liability provider, and say, hey, we're doing virtual workouts now. How am I covered? How does my policy accommodate this? Your workers' comp provider, which sometimes can be tied to your payroll company, for those of you that use a payroll company, how does it cover my trainers for virtual workouts that they may be doing at home? So again, an ounce of prevention goes a very, very long way here. Mm-hmm. And the one thing I'm going to put in the chat for everyone, it is a link to a PAR-Q-based questionnaire. A number of fitness professionals that are on here may be familiar with the physical activity readiness questionnaire. This is probably not appropriate for those of you that are doing group-based exercise, but those of you doing personal training or looking to screen your client on a more in-depth level, there's a couple different tools through this link. That's a basic physical activity readiness questionnaire, and then one for individuals with diseases and disabilities. It's free, it's available online, just a great resource for people to check out. Mm-hmm. So let's expand liability a little bit. And you mentioned this earlier with the person, taking the picture of, their Peloton class, from their bike, and then posting it online. Let's talk about, recording consent. First, maybe define it for us, and then talk about what we have to be concerned with here in terms of an increase in liability.
Yeah. So, perfect example, we're sitting here today, you're recording this, right? We all had to consent in order to be able to join the room. Because you said, hey, I'm going to repurpose this, I'm going to use this, and people are going to watch it after the fact. You know, let's be realistic. I mean, if I'm thinking about a business and I'm really good at training, if I can train and take that content and repurpose it and then sell it, whether to another client or on a platform, which is ways to monetize your content, that's, or through an app or anything, that's great. It's super entrepreneurial. I love it. In the same breath, do you have the consent from the people who are in that video with you? You're consenting, you're taking a video of yourself, you're doing your it's your selfie video of yourself. That's fine. But the minute there's other people in it, I always think of the workout videos where you'd have the person up front working out and you have the 6 people behind them of all different demographics working out behind them, and you're watching the group all work out. Every one of those people consented to being, well, they were probably paid, but they consented to being part of that. That's an important part. I haven't been to a Peloton studio to actually be in live, but I would imagine that in order to walk into that, considering they're recording and rebroadcasting, you're for sure signing away your life and any likeliness to them as part of that. Because that, at the end of the day, when you're training someone individually, if you're going to reuse that content, they have to give you permission to do that. You think about it, they were paying you for your time. You can't now then spin that and go use it for your own monetization without getting their permission. And now that becomes more complicated when you have a group of people. And so, you'll see sometimes where you go into certain settings where they'll have stuff posted up that says, you're entering an area where there will be filming and photography. And by entering this area, you agree to, you consent to having your likeliness filmed, right? Anytime I work with a client, if we're doing any type of event or we're doing anything that's going to involve people, it's going to involve filming, it'll be signed. It's funny. I just yesterday was at a client's office for a lunch and learn. And I happened to notice that, there's people that were not part of the company who were in the room and they were filming and taking pictures. I brought the HR person aside and said, hey, you didn't get waivers from everyone, or you're not going to publicly use this. You're going to use it only internally. And they said, yeah. I said, okay, that's probably okay, because we're all here under consent from you, but you really technically needed a waiver if you're going to go use that later. Never thought about that, right? They're going to take a picture, and if one ends up on social media, I didn't consent to being on their social media channel. Yep. And that may seem like a little thing. And will it go anywhere? Pragmatically, probably not. But I can tell you, I've had clients. I actually have 2 clients, one that already happened and one it's going through right now, where they ended up getting a letter. Someone went and got a lawyer, and we're now spending our time, money, energy, resources to remove content from various platforms and websites because we didn't have consent.
Yeah, and guys, think about it. We all do the little selfie video with our clients or selfie video with our classes. Like those things are great ways to build value in your brand through the social media space. But to Michael's point, have it be video recording or photography recording, like consent is necessary. And I know for us at AFS, that just ends up getting built into a lot of the standard language that we use in our waiver. And then if we're doing specific photo shoots or anything like that, then we put up some of that additional information to make sure we cover our butts, so to speak. But again, it's little details like this that when you spend time up front, they prevent big problems down the line. I have one other follow-up question for you, and this is going to be relevant for both our owners of businesses that are listening and the employees that also do some of these virtual workouts. Who owns the content? So I'll give you a scenario. Let's say, me as the owner of AFS, I have my trainers do workouts for us that we put online virtually. Who owns that? And maybe compare that to the independent contractor trainer that's just kind of doing it on their own and posting.
Yeah, great question. So it totally depends. So what this really, is about intellectual property. So
Yep.
Who owns that content, right? It's not physical. It's not personal property. It is intellectual, right? So you created a video. So it honestly, it depends. And why it depends is what is the relationship between the 2 parties? So most likely the individual who recorded themselves, they're an independent, they did it with only themselves in the video. That's theirs. They can take that, they can post it. They don't have to give consent to themselves. They're using their own likeliness to make money. Good for them. Now, what happens when I'm an independent and I ask you, Michael, to come join me as a special guest trainer. Who owns that content? Well, what's our relationship? Same thing with when you take the relationship to the gym, or you take it to a health club, or anyone who's employing someone, whether as a contractor or as an employee. What is a relationship? Now, most relationships, if I was involved, I would say that content is owned by the employer or the person who's hiring, because part of what we're paying you for is to do the work and for us to be able to produce content. I typically kind of always would protect on that. If I was representing someone who was getting filmed, depending on who they were and what was going on, I'd probably push back on that, right? Or at least have joint rights to use it.
Mhm.
But technically, I would say that, it's going to really come down to the contract. If there was no contract, then it falls on the common law, which is just the case law in the jurisdiction of the region, as to who really owns that. I can say states like California have very different views than a lot of other states in America, but it's something that you should, often you'll hear the words work for hire
Mhm.
or work product. Those are kind of standard language you'll have in an agreement, or that as an at-will employee, anything they produce is owned by us. Most of the standard documents we do have that right in there and covered. But if not, it creates a point of contention. There's been many a case law where quote unquote employee created a social media channel, created the handle for it, created all the content for it, built up the tens of thousands or hundreds of thousands of viewers, and then left.
Mm.
And then there's an argument, who owns that channel now? Or who owns that video? The video got 100,000 views. Whose video is that? And if it's not properly spelled out, all it turns into is a dispute. And so it's something to consider when you're putting this all together, of who actually owns the intellectual property. And again, this is pretty basic language to have in a document. Don't take my customers. I own all the IP, right? Like, those are kind of standard things that the gym owner is going to want to have in there. And I don't think it's, the other thing I would say is to the people out there listening who are independents, oh, well, next time I go negotiate with the gym, I'm going to make sure I own it. Let's be very clear here. This gym spends a lot of money to have the gym, to have their audience, to have the platform. Some of what they're giving you is that entree to be on stage, which is why they own it, right? So I got to be careful, because I know there's two different audiences on here listening. I don't want, all the gym owners to call me back and be like, look what you created a problem for us. All the independent people, part of why they're bringing you on is, yeah, you're good, but they're also trading their exposure for your knowledge base.
Right.
And so that's why you're willing to give them the content, because the other side of it is, if you have 2,000 followers and they have 10,000 followers, you want them pushing it out.
Yeah.
Now, you may want to be able to use it again, but that comes down to the business terms. But I would say, if I had a client who said, hey, I have a gym who wants to do this, I'd say, I think that's a really good thing, considering that gym has 5 locations around the state, and their platform really creates a lot of value for, and it creates third-party credibility. So that's really kind of more of a business term, but that's a really great question that gets brought up a lot by people when they ask me about creating content.
Yeah, and you and I have actually, a lot of things you talked about, you and I have been down that path before. So again, here's another thing where we hate to sound like broken records here, but doing some upfront work is going to really prevent a lot of pain down the line potentially. And this is especially now that it's so easy to create and proliferate content, making sure you have your I's dotted and your T's crossed here. And then I'm also so glad what you said for the independent contractors and the trainers who are listening, to understand the time, effort, energy, money that a business put into building a brand. In some cases, if the brand's been around for a decade or more, I mean, they've spent hundreds of thousands, if not millions of dollars building their brand, and they enjoy some liberties because of that. So
that's correct. I mean,
you can't go in there and just say, demand, no, I own all the stuff.
I mean, listen, there's we all have a client that we want to be able to say we work for, right? Right. I'd love nothing more to be able to tell you the name of the professional team I get to do work for. I don't get to do that, though, because they know that helps me more than it helps them. They're not walking around saying, Michael Melfi did work for us, and they're not posting that on their social media, but I'd be the first to post it on mine that I did work for so and so.
Yeah.
And that's the kind of thing, is that let's face it, as you kind of use that social capital, it's how you get one celebrity client, you want to be able to talk about that celebrity client, or you have one high profile client, you want to be able to talk about him. If you get to go to a trade show or a conference or do content for someone who's bigger in the social scale than you want to use that, but remember, they're giving you something for you using that. So be careful what you ask for in return.
Yeah, great point. All right, well, last topic to get into, and for those of you that are either watching this recorded or watching live, thank you for bearing with us. I hope you found the information to be useful. I know I'm certainly learning some things. Last question is, look, employer, and we kind of touched on this a second ago with regard to employer and contractor agreements. What are things, these are always points of confusion for people. So what are things that both the employer, what do they need to be aware of, and what does the employee or contractor need to be aware of above and beyond just intellectual property and content creation rights?
Yeah, it's a great question. I think understanding the difference between employee and independent contractor is important. I'm not going to try to give any information on that. What I would say is there's a 21-point test. The IRS has it spelled out. Really, what it comes down to is who's paying the taxes is the implication for a lot of people. But there's pros and cons to both sides of that. But just, if you're debating that, definitely get a tax professional involved to assist you with that. But I think once you've made that the distinction of contractor versus employee, the question becomes is, what is the relationship? Does the document you're about to sign really memorialize the relationship you're looking to have? So many times people don't lay out proper expectations. They find a standard form and they just fill it out. I can't tell you how important it is to just take the hour to say, I'm going to hire this person. What is really their roles and responsibilities? And what am I paying them for? What are my expectations? We don't set out proper expectations in general. When you're dealing with a situation like this, what is the real expectations that you're having for them? Having that spelled out is an important part to have in these documents. And then, I'll say this to both sides. It's probably more to the employers. What do the restrictive covenants look like? Restrictive covenants sound like a nasty term. What I'm talking about is the non-compete, the non-solicitation of employees, the non-solicitation of customers, all important points to talk about. And I can argue both sides of this.
Sure.
If I'm coming to the gym with my customer base, I own this customer base, I'm bringing them to you're going to make money off me. Yeah, you're going to pay me for them. So I can negotiate from that position. On the other side, I'm the gym and I say, hey, look at my beautiful equipment. Look at how I keep this place clean. I keep it insured. I just replaced all of this, everything it goes into it. Well, wait a minute. Once they come to me, they're my customers. It really depends what the document says. And it's important to take the time to understand that. And I think it's I would say not all cases are the same. Someone who comes with a big book of business and someone who's starting out with no book of business are very different and should be treated differently. People may not hearing that because they want to use a standardized form, but I don't think all relationships are created equal. You want to have them equivalent, but not maybe equal, in the sense that if I walk in with a certain book of business, my relationship with you may be different. Many a time someone's taken their personal book, moved it into, and now they have their own classes and everything because how big their book is. They just never wanted to have a gym before. That relationship's a little different than someone who's just taking walk-ins. Yeah. And how you treat those relationships is important to talk through. And I think it's better to be upfront about it. Like, that shouldn't be a hard conversation. That should be setting proper expectation. If you want to keep someone long-term, I've never understood that. Like, why not be more upfront? Why not set proper expectations before just allowing someone to walk out the door because of a disagreement over a customer? And so that's all covered in your employment agreements and your contractor agreements. And I'm sure, there's people that don't have it, but what I'm sure of is the people that do just say, oh, we have a form, we have a standard set of documents, we all give them. That's great. And I may even paid a lawyer to put them together. My challenge to you would be do those documents truly articulate where you're at today, where you're at since COVID, and where you're at with the particular relationship with the person. Now, I'm not talking about hiring the person who cleans, the space. I'm not talking about the person who checks people in. I'm talking about these people who you rely on to train your customers, whether it be individual training, group training sessions. What is your relationship with them? And are you doing things that not only benefit and drive your enterprise value, but are you doing things in your agreements to keep them on the team? Because let's assume we all get rid of our bad talent, but the good talent, when that turns over, that hurts you, right? It creates issues amongst your membership. Sometimes subscriptions fall off. You have to deal with that. But if you nip it in on the tail on the front end, you don't have to deal with in the back end.
Yeah, absolutely. Yeah, that outstanding point there. And again, making sure you set proper expectations is just not a good legal strategy. It's also a good business and life strategy in general. So it's, these are two sides of the same coin here. Michael, you mentioned non-competes, and these are always very interesting areas, always very contentious in the legal space. And many non-competes that we've had in our industry for years were pretty standard. It was a certain amount of time and a certain radius that you couldn't work in.
Yep.
Which that works fine when we're all in our brick and mortar facilities. But now what happens in the virtual space? And again, we'll use the disclaimer, hey, go talk to your own lawyer because Michael's not giving you direct legal advice here. But now how does this work?
Yeah, and I think, what's interesting is, like you look at a state like California, for the most part, non-competes aren't even enforceable. Right. So some states are moving totally away from it. And there's even talk about where Michigan's going. But, first making sure the state it's in, let's say you have multiple locations, is even applicable in that state. I think the second part, it's a great question. I can't say that I'm up to date on the very latest case law, but I don't know of the case law, what it's saying for that. Because you're right. What happens if I leave and now, because virtually I'm getting customers? I think it would be, at that point, it would depend on a case by case basis. And it's really, you're going to really want to look at that. Because if someone is, if I just left a gym that was located at this location and I leave and I now start geo-targeting all of my online marketing to within 5 miles, and my non-compete was 5 miles, and just because I'm not physically there and no one's physically there, I'm going and stealing all the clients, there's an interesting argument to be made there in that situation. It's definitely something that, you bring up a point that's exactly why people need to look at their contracts. This isn't trying to create work for lawyers, but there's certain things that you should look at on a regular basis. If we were talking about estate planning, I'd tell you every 3 to 5 years, we should sit down and talk. Same type of thing here. There's certain documents that as things change, COVID changed the world, changed the workforce. You probably want to look at some of your documents, if you haven't, to see if they take into account that. Those are important things to consider, because now how does your non-compete really work? Because maybe it's not just within 3 miles of our location in 1 year or 2 years. Now it may be more than that. You may want to try to put in there language around, you can't compete online with us in these specific areas. Now, is that enforceable? For the courts to decide, but for the employers out there, you want to be looking out for things like that.
Yeah, great answer. And for everyone who's listening, and that was not only, and I might have selfishly asked that question because I would like to know the answer to it, but I will tell everyone who's listening, scary words to hear from a lawyer is it depends on a case by case basis, because that means it's a more complex process. So spending a little bit of time on the front end saves you a lot of pain on the back end.
Yeah.
I feel like that could have been the title of our webinar today.
Yeah, and I always tell that, because no one likes getting on a call about legal. I get that, but I think what it is, it's like preventative medicine. You said it best, and it is. I can't tell you how many times. I mean, unfortunately, we make a living a lot of times, and the people who don't on the front end spend the time, and people think it's going to be so expensive. And I know you can go online and get forms. There's nothing wrong with doing that, especially for the independents and early on. But the minute you can afford it, you're asking people to pay you on either a membership or an hourly basis. You should be accustomed to having professionals who can help you as well, because it's such an important thing to say, hey, can you just take a quick look at this? And you can find a professional who will help you do it and take a quick look at it and give you that. I'll tell you this, I even do it for myself. It lets me sleep easy at night, knowing that someone looked at it and gave me some insight. At least I'd rather know that there's a risk there or there's not than not know. Not knowing is probably worse.
Awesome. Yeah, without a doubt. Michael, this has been great, incredibly informative. We have about 7 minutes left. If there's any questions, please feel free to throw them in the chat. I know we only have a small number of people that are actually attending this live. We will, when we share this, we'll also be sharing Michael's bio and his contact information. If you do want to reach out, we'll be more than happy to make sure that you have a way to get in touch with him. But any questions to throw in the chat before, at least here in Michigan, we get outside to a pretty nice temperate July day. It doesn't look like I'm seeing, oh, hold on, we have one. Okay, here we go. Any fitness specific lawyers you recommend checking out if you want them to look something over? fitness specific
That's,
lawyers. I don't know. I don't know
I
if there
think,
are any fitness specific lawyers.
I don't know. I've if I do enough Google searches, I always find some lawyer tries to say, oh, I've run more triathlons than everyone else, or I've done more bodybuilding, and that makes me an expert, and that's all my clients are that. I would say for this and for the topics we just touched on, I would say that there's a lot of option you go to. Obviously, I do a lot in this space, but if you find a sound lawyer that understands employment or IP, most of them can usually address a lot of the issues we talked about here. But I would definitely, I don't know of anyone in particular who is only fitness only related. Again, I'm sure there's someone out there on the internet who's marketed themselves that way as a good marketing gimmick. I don't know if you're going to get any better value. If anything, they're going to have figured out the form and just charge you the same amount and do less work. But yeah, good question.
I will say this for me, particularly with you, it's really about the person I could have a great relationship with. It's law, at least in our domain, in a lot of respects. And that is a gross oversimplification, I realize. But because I have a great relationship with you, we're able to get things done very efficiently. We know how each other works. So Becky, I would say, look into you mentioned, somebody in the comments there, look into them. They may be a legitimate resource, but I would say it's mostly about finding the person that you can have a great relationship with and someone who values fitness. I mean, one of the reasons that Michael and I connected was through the University of Michigan School of Kinesiology, so I think that was important to me.
Yeah. And I think, you bring up a great point. I don't want to sound like an infomercial, but like having a trusted advisor that you trust, the keyword trust, right? At the end of the day, anyone's going to be able to get you a legal document. It's about the relationship that you have and how does that person create value for you? It's important. I think that's the most important part of it.
Yeah, you nailed it. It's that 15-minute phone call you can have when you're stressed to the nines about something that's completely out of your scope, and you can have a phone call and be like, hey, this is what's going on, and actually get an answer that, like you said earlier, that helps you sleep easy at night. So I think it is, it's finding a good lawyer, good accountant. As your business scales up, these are people that are absolutely worth their weight in gold. So Michael, you are certainly worth your weight in gold for being with us here today. Thank you so much. We're going to send this out afterwards with some additional contact information for Michael. Hope everyone found this informative, and be on the lookout for next month's webinar, probably around the second, third of the month.
Awesome. Thanks so much, Michael. Yep.
Take care.
Take care.
Bye-bye.
Bye-bye.